Well, let's go ahead and get started. I am at Blowing Rock and I have a 10 o'clock meeting, so I'll probably have to bail a few minutes before 10, even if we're still going. But I asked Michael McKnight to join us. Those of you, Jill, do you know Michael?
I don't, but nice to meet you, Michael.
Hey, good to
Okay.
meet you too.
I got to know Michael years ago when I was campaigning. There are a fair number of attorneys who do election law that are dedicated to the cause, and there are those who are objective and give a good summary, a good representation, and treat opposing counsel as intelligent people. So I thought I would ask Michael to join us. I thought this was the one we're going to be having head to head, but it doesn't really matter. Michael, this is being recorded, and all the different presentations will be put together in a report to this commission. So, it might be more entertaining if we had a lawyer so y'all could nip at each other like we've had sometimes. But, we would be very interested in your take on, current post-election law strategies in your experience. And before you guys came in, Michael and I were talking a little bit about an argument before the North Carolina Supreme Court yesterday. I don't think Michael was able to attend, but it did deal with complaints made in the immediate aftermath of the election. So, Michael, I'll toss the ball to you, but Blake, Jill, Bob, everybody is free to ask questions.
Yeah, I just want to re-emphasize for Michael what we're trying to do with this election commission. It's bipartisan. It has a really broad element of people participating, some with election experience, some really just kind of interested good government citizens. But the idea is to take a look at how the election system works and to see if there are particular areas that are problems. And so while it's important to kind of understand from the challenges and the litigation perspective, we also want your insight as to, this works really well, this type of challenge or process, or it doesn't work well. And it's something that the commission ought to look at recommendations on how do you improve it. So, so if we can frame it all and here's how it works, but we also want your experience to tell us, yeah, it works well, or we've really kind of struggled with this. So that's the only thing I would add.
Sure. Well, so I guess I was thinking John Wallace would be on here too, and I started my work with election stuff in a matter against him in 2010. We had a case together where he sued on behalf of the three Democrat state Senate candidates against three Republicans. We had a law that said that if you got the television ad, the disclaimer on your television ad incorrect, you could sue your opponent. Not only you could sue them for the amount of the ads, and then you could get treble damages of the amount of those ads if the disclaimer was inaccurate. So he had gone to court. I got kind of thrown into this because I think everybody else in my office who did election stuff, they were in court on another matter. He had gone down and tried to get an injunction to keep the television ads for the Republicans from running based upon this statute and the fact that the disclaimer was incorrect. And I remember getting called down. It was like a Friday afternoon, and Judge Stevens, I called up and they were calling around to find somebody who'd come down there and represent the Republicans. And I think somebody basically said, "What are you doing right now?" I said, "Well, I was getting ready to go home." They said, "Well, you need to put on a tie and come on down here to court because we're about to enter an injunction." And I think I think, I know, John didn't end up getting that injunction because I think I raised the issue of, the fact that he needed to post a bond. I hope he had brought his checkbook with him, and I don't think he had a checkbook big enough to, or didn't bring it with him to post that kind of bond. So they didn't end up enjoying the ads, and we ended up going on to win the case after he filed a lawsuit. A judge threw it out. I think there were 3 cases that, and one was up in the mountains in Haywood County. It was Joe Sam Queen had sued Ralph Heiss. And a judge, there's a judge appointed by Governor Perdue. I think his name, I can't remember his name. It started with a P. I think it was Gary. If I wasn't trying to think of it, it was not Parsons. It was, I'm sorry, not P. Gary Trawick. Is who it was. He was a special appointed by Purdue, and he heard the case. And we did discover, and we found out that in our case, the Republicans had sent the money directly to the ad buyer, and said though that the ad, it was paid for by the candidate. And in the Democrats' case, they sent the money to Joe Sam Queen's account for 11 minutes, and then in 11 minutes later, he wired it to the ad buyer. And so for that 11-minute difference, they tried to say that the Democratic candidate Joe Sam Queen bought his ad, but the Republicans did not, and the disclaimer was wrong. Well, Judge Trawick heard that, and he said, "Well, if you wired me money to my account and I turned around and bought a car with it, I know who bought the car," or something like that. So anyway, he threw the case out, and it ended up going to the Court of Appeals, and the Court of Appeals ruled in our favor. And I think it was Judge Beasley was one of the judges on the panel who ruled in the favor of the Republicans on that particular matter. But anyway, that got thrown out. The rest of the cases got dismissed, and that was kind of one of my first. I guess it was a pre-election and post-election challenge, but I think it highlights some of the issues that maybe are being heard by the Supreme Court now, where a lot of the post-election things that I've seen and deal with defamation type suits after the elections, things that were said and done in the election, and I guess that's what the Supreme Court's hearing now is there were some challenges filed and people bringing defamation suits arising from those against lawyers and whatnot. I think that's a little troublesome from my perspective. I mean, typically things that are done and said in court filings are privileged, and from the perspective of being of generating suits or that kind of stuff. And I think looking back at that case that I had, the legislature had the wisdom to repeal that statute, which I think it had been on the books since the late 90s, but no one had used it until 2010, and then it kind of surprised everybody that someone could bring a suit like that, and then they could not only hold the candidate liable for the spin by their political committee or some other political committee, but then they could be trebled, and it could result in a personal judgment against the candidate. I thought, who in the world is going to want to run for office if that's the kind of risk that people are facing? And I think that's true when you look at these the lawsuits that are, the lawsuit, I guess the Supreme Court's pending hearing now. I don't know the specifics of that. Wasn't involved in that situation. I think I know some of the people who were, but I think it's unfortunate that people there's all this stuff now where people are trying to personally hold people liable and create liability for them for participating in the election process. And I guess,
Michael,
excuse
me. Let me ask you a question that I don't know the answer for. In those kinds of challenges, does the litigation or the process involve either the local or state board of elections in the context of enforcing the law, or is it simply the candidate or the party coming to you or John Wallace or whomever, and you just go in and file a lawsuit like you would in any other context?
Yeah, for the stuff that relates to the television ads and disclaimers and all that, you can file complaints with the Board of Elections. It would really be in the campaign finance part, though, claiming that someone got their disclaimer wrong. I think that's still in the statute. I think it might be a misdemeanor to get the disclaimer wrong on either a mailer or a radio ad or television ad, or not to include one, something like that. So that's one avenue that you can go. That particular statute that I was talking about created a civil cause of action. It was basically like kind of like an unfair and deceptive trade practices statute for ads is what it was. It had the same, you got attorney's fees, treble damages, that kind of stuff. But in order to get the money, you had to show that you had clean hands, that you as the plaintiff did the same thing. In that case, the judge found that both sides had done it and engaged in the same sort of conduct. So he was going to enter a judgment. Anyway, it's kind of a mixture, and that's I guess that's what's going on in the present case now, is that people are pursuing these civil claims for defamation outside, but based upon a challenge process that attorneys went through. And I guess, when all that kind of stuff happens, one concern is whether there's going to be attorneys who are willing to take on those cases anymore. And I know for me personally, Bob introduced me as an election lawyer. I think I'm a retired election lawyer for that reason. For one thing, these challenges, they're a drop everything type of deal. And I do all employment now, and a big hunk of my practice is OSHA work. And so that's a drop everything kind of deal when there's an accident or injury or something like that. So it makes it difficult. You can't have but so many areas of your practice that are drop everything. This is on fire. That's one problem. But the other problem, the realistic problem, and we've seen this in law firms across the country, is that there's all this people now, rather than just say, oh, everybody deserves a lawyer, voices need to be heard and that kind of stuff. They want to hold lawyers accountable for the positions that their clients take in this matter. And really, there's no one out there defending lawyers saying, wait a minute, it's important that everybody have representation in these type of matters. But instead now, people's law partners want to look and colleagues want to look and say, well, I don't agree with the candidate you're representing, so I don't think we should do that. And more importantly, clients complain about that. They say, I've seen, these cases tend to be very publicized, and they'll say, oh, I've seen one of your partners out there representing so-and-so. I don't agree with that person, or I don't agree with that position. I don't know why you guys are doing that. I'm going to move my work somewhere else if you guys continue doing that. So what's happened is, and what I've seen is that people at larger law firms are no longer taking on these types of representations. And you've seen that nationally. I know that Paul Clement and is it Aaron? I forgot Aaron's last name, but his partner over there, who handled several cases for North Carolina in the redistricting and voting rights context, ended up having to leave Kirkland and Ellis. It was a public thing because they had represented Republicans and other things and those types of things. And I know that at Perkins Coie, Mark Elias, who's been involved heavily in North Carolina cases over the years, ended up leaving Perkins Coie. I don't know the reasons, but he and his team, who were, I guess they were most famous for representing Hillary Clinton in her campaign and all that, and a bunch of other stuff since then, they ended up leaving Perkins Coie, which is another big firm. That was known for representing Democrats over the years, and I assume that some of that has to do with people having heartburn over those types of representations and the impact they have on recruitment and colleagues and clients and all that. So a lot of these people end up going and starting their own firms, and the people who are doing this work now are often at smaller law firms. And I think that's a real problem. And what I've seen when lawyers were criticized, like I guess the people who represented Trump in certain election challenges, when they were criticized, no one stood up and said, wait a minute, everybody needs a lawyer and all that. And I think that the consequence of that's going to be probably more frivolous lawsuits in this context than less, because you're going to have, I think, fewer good lawyers willing to take on these cases, and more people who are willing to they'll hire anybody they can get who will say anything that they want to say. And I think that's a real concern. So I hope someone at some point will start addressing these issues and stand up and say, we really need good lawyers to take on election cases, and it's not fair for lawyers to be held accountable or branded because they take on a case for a particular client or particular side. We need good people because we need to go through the process. We need the system to work to determine what's a legitimate challenge and what's not. And I think, that goes to the purpose of your committee, which is to determine, what ways can we increase confidence in the election process. And I think the way you increase confidence is by having a thorough process with good advocates on each side, and then letting either the courts or the appropriate election body decide what's supposed to happen. But anyway, I think, yeah.
Is there any way, and the answer is probably no, but to take some of this, you got to do this immediately, pressures off of lawyers. I think, all of us as lawyers, I mean, that's the worst thing is, drop everything, put your tie on and show up in court, or
Right.
particularly for old lawyers, it's even tougher. But from a process standpoint, do you see anything in that? You don't want to try and limit people's ability to challenge problems, but is there a winnowing process, a way to take some of the pressure off lawyers?
Well, so I saw I was going just to kind of update myself on where things are at. I saw there was that session law, I think it's 2023 140 or Senate, it was Senate Bill 747 became law late last year. I think it expanded the timeline for challenges like on absentee ballots. You don't have to do it necessarily by 5 o'clock the day of the election anymore. I think you got 5 days after the election. I think you're right, when there's more time to think through challenges. I think, part of the problem where you get inaccurate pleadings and inaccurate statements and all that is when everybody's running around, they don't have time to think, they don't have time to think through things, and they don't have time to talk with the candidate about, okay, do we really need to bring this challenge? Because I think with the deadline delayed like that, then you get to look and see, okay, do we even need to do this? Is it going to affect the results? Because if the other candidate's so far ahead, what would be the point? Who would want to spend the time and money doing that? And then two, it gives you time to get the facts together, to talk to all the people you need to talk to figure out, is the person who's providing me this information, are they legitimate, or are they, are they likely to be telling me the truth here and all that? I mean, all of us as lawyers depend upon the people who are our clients and people who are witnesses in these cases to be telling us the truth about what's going on, and not telling us what they think we want to hear, or telling us something that because that furthers an agenda or a goal that they have. And I think we all have a duty to try to vet that out. But I think you're right. I think some additional time would help. But on the other hand, in the election process, you don't want to delay things too much either, because I think that creates skepticism. All these situations where ballots showed up after the fact, after election night, or things look one way on election night, and then there's some big seismic shift the next day or whatever, that undermines confidence in election. It allows these conspiracy theories that are false to fester. I think so. I think it's kind of a balance, but I do think it's almost impossible to get a good, accurate result if you're trying to run around and do everything on election day and all of that. So it looked like that this bill helped cure some of that problem. And I know that I guess there was some opposition to it, but it looked like to me, giving everybody a little bit more time worked, and that 5 days is because I think canvass is like 10 days or 2 weeks out from the election. So it's in plenty of time for the canvass and all that. And it looks like to me, it would allow legitimate challenges to be brought, vetted, and determinations to be made. I mean, I think it is a tough situation though, if a challenge results in there's an announced result on election night and it results in a reversal of an election. But I would think in the cases where that occurs, that's going to be a result where there's just very few votes separating the candidates, and people might be expecting to see some changes occur between the announced results and the canvass.
Yeah, I know I'm asking all the questions, and Jill and Blake, Bob, you just have to cut me off. And I'll sort of ask this to Jill also, who has represented Democrats in election cases. Do the political parties who are now more attuned to filing lawsuits and challenges surrounding the elections. Do the party structures kind of understand, the attorney's responsibilities to, sort of follow a process, and you just don't file something because somebody heard something from their neighbor who was a poll watcher a county over or something like that. I've seen, and this is probably true for the Democrats, but I saw something that the Republicans that are looking at being more proactive in filing lawsuits, and so I'm wondering from the standpoint of working with the parties who are bringing in lawyers for elections, if they have a pretty good sense of how it's supposed to work versus, we're here to lawyer up at the drop of a hat. Jill, you want to answer that for the Democrats?
Yeah, I didn't know I was waiting for Mr. McKnight. I mean, I don't think that the legal process is built out at all or enough within the state Democratic Party. I'm on the attorney committee for that too. And right now we're working on getting counties different, like local party attorneys. But like New Hanover County is very, very well organized, and we don't have a county attorney. I essentially play that role, even though, I don't have a North Carolina law license. I could not take anybody to court here. It is something that we're working on more, but I will say for us, after the 2020 election, the courts were used as a weapon and a tool to delay, and there were talking about if there's legitimate claims or not. I think there's also a problem with that. And if you spend too much time afterwards, you are essentially allowing political strategy to come into play to use as a tool or a weapon. And I don't agree with that either.
Right. So using litigation as a political tool as opposed to
A legitimate.
legal remedy. Michael, what are you seeing on the Republican side? They seem better organized than our friends on the Democrat side.
I think that's true. This time, my involvement, I started out as a volunteer county party attorney for Wake County, and then I eventually served as the general counsel of the state Republican Party during the early McCrory years, and at the time, we had, there was varying levels of organization. I think at all those, there's always been a county party attorney, at least in the major counties. A lot of the more rural counties maybe did not have at least a volunteer attorney, and for the state party, that was a volunteer position too. Now I will say, Republicans, a lot of them don't have a lot of use for lawyers because and I think it's probably true on both sides, because a lot of times the party lawyers got to say, got to be the person who puts their foot down and says, not only is that a dumb idea, it's illegal, and it does that. You don't win a lot of friends a lot of times doing it. And sometimes, when somebody doesn't want to do something, they turn to you and say, all right, you need to find a way to explain to people why they can't do this, and you've got to provide you've got to be the person saying no, that we can't do this, or this is not a legitimate challenge, or that this is not a legitimate position to take, or even if it is, if we take this position, we're likely to lose for X, Y, and Z reason. I think it's a tough job, and particularly when it's a volunteer gig, it's tough. I always thought the Democrats paid their lawyers they had more paid attorneys than we did on our side. I don't know if that's right or not. That's always been my impression, and in commiserating with the the folks, with the attorneys on my side, we always thought that. I don't know. May not be the case now, but anyway, I mean, I think, in terms of, the timing of challenges and things being used as a weapon, I would agree that, I know that there was during the COVID years and the 2020 election, there was a lot of concern about certain, absentee ballot practices being relaxed, absentee ballots being mailed out to multiple people in places like Pennsylvania and all that. And then those practices would be challenged after the fact, after the election, after the results were known. And I never quite understood why that happened. I think it's because maybe people weren't thinking about all the ramifications. I think if you have if you have a concern as a political party or candidate about an election practice, you know what the rule, if you know what the rule is in advance of the election and you have a concern about that practice, then I think it's like a lot of other election changes, like the same thing with redistricting and other voting changes. There's a general rule that you don't go and change election practices or voting lines or other things too close to an election. But on the other hand, I think it's better to challenge those practices in advance of an election rather than afterwards. And I think some of the concern that I had with challenges that were being posed perhaps on our side after the 2020 election is I didn't understand why not North Carolina specifically, but in just looking at it as a layman from other, or at least as a lawyer, layman lawyer from other places, I didn't understand, like, if there were concerns about the absentee ballot process in Pennsylvania, why not bring those earlier so that they could be decided before the election results were known, before people voted, and everybody would know what the rules would be, even if there was a last minute change. If there's a last minute change by an election body, then there ought to be room for a last minute challenge, but we ought to be able to tell people ahead of time what the rules are, and we ought to get that straight in advance, not after the fact, and where we're going and having to say, okay, we want to invalidate, we think that what this announced practice was illegal, so now we're going to invalidate a bunch of votes that were cast. I think that's very concerning, and it undermines faith. But on the other hand, I think what we were just talking about, having a challenge after allowing some time after the election, rather than saying, okay, all ballots must be challenged on the day of the election, allows time for people to again decide what's legitimate and what's not, gather evidence, vet it out, make sure that the statements that are being provided are accurate, that kind of stuff, rather than just trying to throw something together because you got to meet a 5 o'clock election day deadline. I think it'd be better to take more time for that. I mean, I understand the concern about having it appear that you're using the courts to game the system or reverse an election result. But I think there'd be very few instances where an election's that close where you're gonna do that. And if it is, then I think that there ought to be time to get it right. If the practices were known, and the question is, did a voter or someone else appropriately follow those practices?
I'm going to ask another question. So, both for Jill and Michael, is there any real training on the part of parties with their lawyers? And I see Jill shaking her head no. But I mean, it seems to me one of the pressures is, the political side, regardless D or R, they want to win the election. The lawyers obviously have a professional responsibility not to bring frivolous lawsuits or make unjustified claims, but you're getting political pressure. No making a difference whether you're a Democrat or Republican. Your side's putting pressure on you to do something. And so one, would there be value in some entity, whether it was the Carter Center, whether it was the Bar Association, that brought together lawyers from both parties, maybe leadership from both parties, well in advance of an election, to talk about, all right, let's talk about how this works in a good government sense, not in a partisan sense, but in a professional and sense. I mean, would there be any interest? Would there be any value?
I would love that. I mean, in New York, we did get a lot of training, or there were all kinds of, seminars, workshops, things that help put voter protection legal teams together and whatnot. In North Carolina, since moving back here in 2020, I've been like a little appalled at the lack of infrastructure for elections related attorneys within the Democratic Party. And they are trying to rebuild it now. But yes, I think that would be wonderful to have some kind of bipartisan training. As you said, we have a professional responsibility to bring forward real legitimate challenges and make people feel that they can trust elections. And I think training would be wonderful, fully supported.
Would the party be interested?
I think so.
Yeah. Okay. All right. Michael, any thoughts on, I know you can't speak
Right.
directly for the party, but yeah.
Right, right. Well, I mean, what I can say though is on our side, we had training of this sort, not only for the attorneys, but for the people who were going to be poll observers. And I know that when I did trainings or oversaw them, that we made clear to poll observers that, you know, what the rules were about the importance of not even appearing to intimidate voters or anything like that when you're serving in those roles. And what the job was to observe and document accurately and then report back. And it looks like to me some of the changes that are in this most recent law that allow, you know, poll, I know there are a lot of concerns about having these kind of roving poll observers and all that in counties and statewide, but I think those are largely good things. They allow people to go in and out. They get, I think to me, it puts to rest a lot of these conspiracy theories that are incorrect about what's going on, because the parties have been able to put people in polling places. It's hard to get coverage everywhere and train people to have coverage anywhere. But I know that with the roving observers and all that, there is training for those people so that they know what to do. They know what the legal boundaries are. They know what their rights are. They know what they shouldn't do. And really, I didn't see a lot of issues on our side with people overstepping their boundaries and all that. So I think the Republicans do a good job of trying to train their folks on what they're supposed to do. Doesn't mean that there's every circumstance where somebody follows a rule. When I was doing it, I didn't hear about many. Sometimes people would call in about things that weren't issues. A lot of them weren't issues, but they were nonetheless, they were reporting their observations fairly. And we always had a war room set up, I'm sure the other side does too, that took these calls from people, took notes, and then that was escalated to another group of people who determined, you know, is this something we need to pursue or drill down on, or is this sort of a nothing type something? And in most cases, it was really nothing to be concerned about. But I mean, I think I mean, for this side, I think it's as organized, and it's far more organized now from my interactions and having been in these war room situations in this decade, even more so than when I was more heavily involved as a party council. I think it's only improved. I mean, do I think that I don't know that there's going to be an appetite for any type of bipartisan training by a bar association or some other election center or anything like that. I think each side is going to want to train its own people in its own way, and you know, I just don't think there's going to be much appetite for that. Does it mean that there's not an appetite to have conversations about how we can improve processes? I mean, I think yeah, I mean, I think people might be open to considering, are there things that we could do that might make these processes run more smoothly? Because a lot of times lawyers think where people make errors and things get spun up in inappropriate ways, I guess, or where people don't know what the process is. They don't know, you know, I think it'd be helpful, for example, if all the courts had a contact. If there needs to be a last minute challenge or somebody going to court, everybody knows, number one, who do they contact? Who's the court? Because I know the Supreme Court does this. Usually there's a contact who's available on election night to hear emergency appeals and injunctions and stuff like that. I think it'd be good if the courts in the counties and elsewhere have a contact available in case somebody needs to go to court about something, and then those people would know also who to contact on each side, so that one party or a candidate's not running around trying to find who their lawyer is going to be and get somebody there to represent them. That there's people who ahead of time know that if an issue arises, they're going to be contacted and they're going to go and handle it, and they know who's going to do it. I think something like that would be useful, so that it's not just someone calling somebody they knew, or who has the best, you know, whichever party has the judge or the clerk in that particular county is going to get an advantage. I think if you could eliminate that, those might be good government things that people could come together and agree upon. I think lawyers generally, they want to have a known process so they can explain to their respective clients, okay, if we have a problem, this is what we're going to have to do. This is what the expectation is. I think it'd be good to know if you're going to bring a injunction suit in a different county, in a particular county, what the rules are and what the expectation of the judge is, the types of things that they're going to, entertain, that kind of stuff. So maybe there could be a bipartisan usefulness for something like that.
I mean, to be clear, like we get plenty of training for poll observers and for regular volunteers. I'm speaking specifically about attorneys and post-election or any sort of challenges. There is no real training or any kind of guide that way. We get lots of training about poll observers.
Yeah, and I guess I'm thinking, Michael, you had said when you were talking about the, lawyers becoming more reluctant to get involved in these for a
Right.
variety of reasons, that some sort of even-handed training where your speakers are not one side or the other, but you bring in Phil Strack and Press Millen, for example, or John
Right.
Wallace,
Right.
on a panel, with a degree of professionalism emphasized in it, that you go in as a lawyer, not as a partisan.
Right.
That maybe one, it would encourage some lawyers to say, okay, yeah, now I'm a little more comfortable with the process. But to Jill's point, if the lawyers aren't getting the training, and as we all know, the election law is not the simplest area of the law.
Right. Right.
And so, it may be too short a notice to try and pull together a CLE for September or
Right.
but it would seem to me, from a professionalism standpoint, from a competence standpoint, and from a depolarization standpoint, which is one of the emphasis that our effort is aimed at, that there would be some value, even if it was just a Zoom conference, or maybe you get CLE for it, so there's some incentive to do it.
Yeah, well, I guess on our side, in terms of training lawyers, I mean, we had training for lawyers as well. And I guess I was thinking about lawyers who are overseeing poll observers, going to serve in a war room, going to be, because a lot of times we have folks who are lawyers who do serve as observers and stuff like that. But we do, so I guess the Republican Lawyers Association usually does a CLE around that time to help our folks get acquainted with the election laws and stuff like that. But I mean, I think, if you had I guess it's possible that if it was done far enough out, and again, you may be right. I think maybe this cycle we may have blown it, but if it could be done far enough out where it could be useful, and it was a situation where people, the bar association put it together, and you had true bipartisan input, panels. I think people who are interested in volunteering and all that, it might be well received, and it'd be a chance for everybody to kind of get to know each other, because it does make it easier when you know the person on the other side too, and you can call them up and just say, what can we do to try to, and a lot of times with these things, you can't work. There's not a room for compromise. One person's got to win, one person's got to lose. But sometimes there is. Sometimes there's a way we can work something out. And I think knowing each other is, I mean, there's certainly value in that. So maybe if it was well planned and it was a truly bipartisan affair and people saw it as such, then I think there might be an openness for people to participate, at least get some ideas from that. Doesn't mean that each side can't do its own lawyer training from a partisan perspective or whatever, but at least we could, it might be just an update, because I don't keep up with all the changes that occur every year and all that. Just a general update, that kind of stuff. Maybe there's an opening for that. I don't know.
Yeah, well, one of the things that we're trying to emphasize is giving people confidence in the system. And you hear people say, well, that election was stolen. Well, you may have disagreed with some regulatory change by the Board of Elections or some statute. But if there is a legal process that plays out, even if you lose it, I mean, then that's not stolen. That's, you just lost, the argument on the legal issue. And so I don't think the public understands the legal process.
Right.
And so, I think part of our mission is trying to figure out if you jump in and file a lawsuit the day after the election in a particular race, that people understand this is the way it's supposed to work, and you may win, you may lose, but everybody's going to get a hearing the way you're supposed to. Anyway, I mean, I think I've asked too many questions. Blake, Jill, Bob, Bob just wants all the lawyers to send money to the Bar Foundation.
One thing that I have been thinking about, and I think might be significant for our discussion, is some of the things particularly gone on that recently down in Georgia, where Giuliani was saying that the poll watchers and the people on the Board of Elections and so forth crooked, and got hammered for it. And I think that's something that the parties might be able to work on too, is saying your fight is not with the people who are monitoring the elections. Your fight is with the opposing party, or something along those lines. But these efforts that have been made that bring people to question whether or not our elections are valid, I think it's really acid eating away at the foundation of our process.
Yeah, and certainly that's something we want to do, Bob, is to strengthen support for election workers across the board, and lawyers can help in that. I mean, I think instead of lawyers attacking poll workers, you attack the rule and you assume that it was applied correctly. And if you think somebody didn't apply it correctly, then that's one thing. But yeah. Blake, you got any questions or?
No, I mean, I don't have any questions. I think one of the comments that was made that I really appreciated and I think is important for the purposes of this group is what Michael had said about the changing of laws before elections and how that doesn't build confidence. And obviously 2020 was a very unique situation, but at the same time, right, if we want to prevent sort of the critiques, right, how do we how do decision makers use good judgment and build confidence? And I don't know if there's a great answer to that question, but I think that that's something that we just got to consider.
I know we're bumping up on Justice Edmonds. I see people in suits walking behind him, obviously getting ready to head to a meeting. But
we're all very loud.
Yeah, Michael, Jill, anything else? Michael, any other points you'd like to share with us? We really appreciate you taking time to do this, and we would encourage you to get back in the fray.
Yeah, I'm still involved. I'll still, still involved from a volunteer perspective, but I think for the reasons I've highlighted, I think it's very difficult now to take on, paid work without being, because you end up getting, you end up ticking somebody off, either somebody that you work with or somebody who's a client. I've got clients of all stripes, and that kind of stuff, and people, I just feel like before very recently, people didn't take all this so personally. I feel like for whatever reason, since the Trump years, all of this is just so very personal for people that if you align with one side or another, then that is like your entire identity and everything else. And I think whatever your committee can do to try to undo that and undo it, particularly for lawyers, so that lawyers can participate in the process legitimately, if it's bringing people together for something that you're talking about, as long as it's a true bipartisan thing that people have confidence in. I think that might help, but letting people know, yeah, we want lawyers involved on both sides. We want them to be well trained. We want to that kind of stuff, and that's a legitimate thing to do. It's an important thing to do. It's a civic thing to do, and it doesn't matter which side and that kind of stuff, because I think a lot of times, I mean, I know on my side, I've been able to work with people to think through ideas and maybe talk people out of some things that maybe shouldn't have been done, and think about better ways to do other things. I know that goes on both sides, and at the end of the day, usually the people you talk to were grateful for that. And because when they look at situations like the ones that are at issue now, where the Supreme Court's looking at, they're grateful they didn't get sued for defamation following an election, or sued for or charged with something and all that. No one wants to do that. Everyone should be able to participate in the process, know what the rules are, and have confidence that, yeah, they're going to be able to continue on with their livelihood and their freedom too, after participating in it. So I think everybody wants to get it right. It's just a question I can do it. So if there's something I can do to help you guys, on that mission, I'm glad to do it. And I certainly will. Our firm encourages people to be involved civically, certainly on a volunteer basis and stuff like that. So I'm going to continue to do that and provide my input for whoever wants to hear it. But I do think that's something that needs to be looked at, corrected over a long-term basis. Go back to where it was, where it was an honorable thing and a good thing to represent people in election matters and that kind of thing. So I don't know what we can do to make that happen, but I'll leave that to you wiser minds to figure that out.
Well, it certainly fits in our wheelhouse of what we're trying to accomplish, I think,
Yeah.
with this commission and generally with the Carter Center's effort. Do you know who will be heading up the legal efforts for the state party now?
I don't know. I know my friend Rose Ferguson is the legal counsel currently. I hadn't talked to him in a while, but I can certainly check with him and find out whether he's the volunteer general counsel, which is the same position I had back in the day, and so he's been doing that for several years now. But I believe they have somebody on staff who's also, they have one or more in-house lawyers over there who would, I imagine, be putting together that team and looking for volunteers. I know Philip Thomas, who's an outside lawyer, used to have that role, and he's involved with the Republican Lawyers Group who helps put all that together and all that. I certainly can reach out to them and find out, who's the contact, and they may have interest in looking at something like that.
It'd be great. Jill, do you know who the Democrats?
I mean, we're meeting as like a committee now, but it's probably Mr. John Wallace.
Okay. All right. Well, super. Michael, thank you again
Yep.
for doing it. And Bob, thanks for setting things up at the luxurious Chitolta Lodge in Blowing Rock. Yeah.
You'd love it here.
Yeah.
When's our next meeting, Bob? Is it May 9th?
Yeah, Rachel, or you
It's
on?
May 10th.
May 10th.
And that is the meeting that John Wallace is going to join us.
Okay. All right. Well, gang, thank you all, and Michael, again, thanks
Sure.
For your participation, and we will be calling on you. I still think of you as one of those young lawyers.
Yeah, I don't
you've
feel
been
like
doing
it
it a long time now.
I know it's been like 17 years. I mean, it's been way too long.
Yeah.
I know we go back a long ways with both of you, so I appreciate it.
Yeah,
All right.
sure. All right, guys. Thanks so much,
Thanks.
Rachel.
Good seeing everybody.
Take
Yeah.
care.
Sure.